This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
As the 21st century is rapidly approaching, a major effort is underway to bring the New York State court system into the next millennium. Today we'll talk with the Honorable Jonathan Littman, Chief Administrative Judge of the State of New York, and find out how these changes will make the court system operate more efficiently. Hello, Judge Littman.
Oh, it's a pleasure to be here, Alan. How are you?
I'm fine, Judge. Now, you administer a court system with 1,300 judges and 13,000 employees. What is the state of your system?
I think the state is good. I think we're doing a lot of positive things, and the court system is healthy. And we have judges and court personnel who are working very hard to serve the public, and that's our main function. And we are performing it, and I think well, and often under difficult circumstances.
Now, I know the New York State system handles more cases in one day than the federal system handles in a year.
Yeah, I don't think there's any comparison between the two systems. Certainly the federal court system has a lot to be proud of, and our counterparts in the federal courts deal with very difficult and complex cases as we do. But in terms of the volume and the numbers of people that we serve and the numbers of cases, they are two different worlds. And I think the caseload volumes are what make the caseload volume is what makes the state courts so difficult to administer and so difficult for our judges to serve on an everyday basis.
Judge, let me ask some tough questions.
Sure.
You're the fourth chief administrative judge over the last 14 years that we've had on Lawline. Each administrative judge comes on here with wonderful ideas of what he is going to do with his program, and the facilities is always top amongst. Some of the courtrooms that you walk into, some of the courthouses you walk into, you see paint peeling from the ceiling,
right.
And they're really less, they don't give respect that you should have for the system. What do you intend to do about that?
Well, I can tell you what I intend to do, and I've started doing already. First of all, I spent a lifetime in those same facilities in the courthouse. As you know, that I've spent the great bulk of my professional career in the courthouse, mostly in Manhattan in the Supreme Court. And many of the courthouse conditions are abominable. And we are working, we have something that's called the Capital Facilities Legislation, which gives us certain weapons to use to ensure that localities meet their responsibilities in terms of taking care of the courthouses. And most of the localities in the state, including New York City, have submitted plans that have been approved by what's called the Capital Facilities Board, in which those localities work to maintain at least adequate facilities in keeping with the dignity of the judicial process. We work, and I've worked really in my former position as the deputy and now as the chief administrative judge, spend an inordinate amount of our time working with the localities in a combination of cajoling, berating, collaborating, threatening, being inviting. We each and every day work with the localities, and to give you New York City as the example, we have in the last, I'd say, week or so been working very hard on a plan to have some of the city projects that the city is building working now in concert with the Dormitory Authority, who has a very good record in building courthouses quickly and efficiently, and a lot of those buildings, some are being built by the city, some are being built by the Dormitory Authority, and we've just recently been finalizing negotiations with the city on the Dormitory Authority doing more of those courthouses.
We're getting courthouses, more courthouses?
You are going to get courthouses. The question is when. All around the city, there are projects in each and every county in the city of New York to build additional courthouses in Brooklyn, in New York County, in the Bronx, in Queens. We just opened a new courthouse in Queens, Q1. and there are new courthouses coming. The issue is to be raised is when, and we're working collaboratively with the city to make sure that they come in within a master plan which takes place into the next century, but certainly starts. There are different projects in the construction phase, design phase, and on out into the next, over the next number of years. So what we're doing is spending each and every day making sure that that capital plan is met, working with the city, working with the Dormitory Authority, and then on the other half of it, making sure that the maintenance and upkeep of the facilities are what it should be. And certainly you walk into many of our courthouse facilities, the jury facilities, the deliberation rooms, they are not what they should be. And we have spent, for the furnishings, appreciable amounts of court dollars to make those furnishings better, and the city should be maintaining, and we have worked with them, and they have a program called a WEPS program, Alan, which they're using welfare workers to supplement the workforce, and this was an agreement that we were able to come to with Mayor Giuliani to increase the maintenance, the number of workers dealing with maintenance 4 or 5-fold from strictly the city workforce.
Let's talk about the jury system. Now, you mentioned the jury rooms. Now, I know you and Chief Judge Kay have worked very hard on the jury system to make it more friendly to jurors. Can you tell the viewing public what they can expect when they're called down?
Okay, well, they can expect lots of changes from the last time they were called down. There are 3 different prongs to the jury program. The first one has to do with making the jury pool fairer and more representative. And we've done a number of things, putting modern equipment into the commissioner of jurors' offices, better follow-up procedures, better lists of jurors. The legislature has eliminated all automatic jury exemptions. We've also, instead, I'll tell you exactly what
you were just called.
That's right. I am delighted that in Westchester County at the end of February I will be serving on a jury.
That'll be interesting.
And what it shows is I will be doing jury service. Will I serve on a jury is another question, and we'll see. But the point is that it shows that the system works, and people like myself, whether it be judges or doctors or lawyers or podiatrists or governors and everybody else, public officials will all be called to jury service, and it makes a great statement about the court system. It makes a statement that both the benefits and the burdens of jury service are going to be spread evenly among the population. And there aren't 2 different classes of citizens, some with these automatic exemptions and others who serve like clockwork every 2 or 4 years. What's changed is, instead of being everybody is exempt and no one serves, now it's everybody serves and no one is automatically exempt. But what the public has to look forward to, if they do get a summons, it still is a flexible system, and if they can't serve because of capability or hardship, they can still get a postponement if it's appropriate, if they really can't serve. In fact, by law, the first postponement can be up to 6 months to a date of your choosing, to do at a time when it's convenient. So these kinds of changes on this first prong of the program, again, say to the public that the jury system, we all have an investment in the jury system, and we all can make it better, and we all can serve. And again, I'm delighted to go in and serve, because I think it does make a statement that here, lawyers, judges were always exempt. Now the situation is changed.
What about mothers with young children? Are they exempt?
Nobody is exempt. However, mothers with children, if they can't serve, they can seek a postponement or an excusal.
Until the child is older?
Right. What you have to show is the 2 main tests, and it gets into more detail, but the basic tests are capability and hardship. That's the basis upon which you would seek a postponement.
What other changes in the jury system?
There are great changes. The second basic thing that we've done is they're going to have a more, inviting place to do their service when they come in.
Coffee and cake?
We have an espresso cart now at 60 Center Street.
Very nice.
We have better furnishings, amenities, places for people to work. We've improved their pay.
What is the pay?
The pay is $15 a day, will be coming $27.50 a day shortly, and then up to $40 a day. And in addition, we have 800 numbers where people can call for assistance. We have civility training and awareness training for our employees to treat jurors better. And jurors are going to find that they can have a very welcome reception when they come into the courts. The goal is to have them want to serve. And what's happening is, and I'll tell you the third part of it, which I think as lawyers are very interested, the voir dire process, but the bottom line of broadening the pool and making the experience more inviting is we're having yields of jurors, meaning how many people come in when you get the summonses that are like double what we've gotten in past years, and it is absolutely fantastic. The commissioners of jurors have never seen anything like it. The response of the public in coming into the courts and wanting to serve, all this focus works. People want to know what it's about.
Can a person call up and say, hey, call me, I want to serve?
Yes, they can volunteer. They should call 1-800-JUROR, and they can absolutely volunteer and get on the list.
And the third part?
And the third part is the streamlining, which lawyers should be very familiar with. New rules went into effect on January 1 to streamline the voir dire process, the jury selection process. And the basic change in this, there's 4 changes within it. The most significant is that judges now supervise the voir dire.
And what kind of response are you getting from the attorneys? Is that working?
It is working, and I think if attorneys give it a chance, which they are, it's going to work better and better, because the end result of it is twofold. One, the process is more efficient. Our studies showed, and our pilot studies showed, that the voir dire was much faster when judges supervised, even if just part of it. And, I think that is a real major change. The second part of it is, with judges supervising, at least to some degree, the voir dire, you elevate the whole tone of the proceedings. Instead of jurors coming in, never seeing a judge, waiting in some back room, and then said, okay, now you can leave, they have an idea what it's all about. They see a judge, they see a process that's a court process.
Judge, let's discuss it. How are judges actually selected? You're the chief of 1,300 judges. One, how selects the judge?
Well, there are a number of different ways. We have a mixed system in New York State, which is both an elective and an appointive system.
Appointed meaning merit?
Merit in various forms. Merit selection, there are, basically means an appointed judiciary through some merit process. Okay. And those processes are somewhat different depending upon the court. But in New York State, we have, for instance, in New York City, the Supreme Court is an elected court.
By the people.
Elected by the people. The family court is an appointed court, appointed by the mayor. The criminal court is an appointed court, appointed by the mayor. The civil court, elected by the people. The court of claims, which is the court in which my underlying judgeship is, appointed by the governor. So there are different kinds of elective and appointed
However,
judges.
some critics of the elective process say it's really not an elective process, but it's a process run by the county leaders who select the nominations in heavily Democratic or Republican jurisdictions. How do you feel about that?
Well, in general, institutionally and personally, we have always been in favor of a merit system. But I would add that within the court system and within the legal community, as you know, there's great differences of opinion about the elective versus the appointive system. I give you a particular example of where the elective system has shined in recent years. You look at minority representation in the judiciary. The elective system has been better at getting a judiciary that is more representative of the general population. So a lot of people say, in fact, minority representatives say today, now that we're getting a fair share of the elected judgeships, now you want to change to an appointive system. Keep an elective judiciary, it represents the public.
Critics of the merit selection say if it was only merit selection, you would have the presidents of the bar associations and the non-minority people in that. I would like you to think about that, because we're going to a break now, and we'll respond right after the break.
Great.
You're watching Lawline. We're with Judge Jonathan Littman, the Chief Administrative Judge of the State of New York. Stay with us.
In a life-threatening emergency, you should know what to do. Say a loved one exhibits unusual symptoms. The first thing to do is...
Clear!
No. The first thing to do...
Oh! Tourniquet!
No! The first thing you do is pick up the phone and dial your emergency number.
Call 911 first.
Right.
How about mouth to mouth?
I don't think so. To learn more about life-saving techniques, contact your Red Cross.
Your approach is looking to cover.
The men and women in the National Guard and Reserve face some tough challenges when they serve. Challenges that teach them discipline, leadership, and technical skills that make them better employees. So when they need time off to serve, don't make their toughest challenge approaching you.
Hello, you're watching Lawline. Today we have with us the Chief Administrative Judge of the State of New York, Jonathan Lippman. We're talking about what the system does for you. Judge Lippman, right before the break I was discussing the critics of the merit selection system of the appointment of judges, saying that if it was selected by the bar associations and the committee system, you'd really only have lily-white judges, and it would not be a representative sample of the community. How do you respond to that?
I think that an appointive system can work wonderfully. It does have to be representative of all the constituencies out there affected by the justice system. And I think it's fair enough to say that the merit system can work beautifully. Look at the Court of Appeals. We have a screening process that's representative of the different parts of state government are appointed to a screening panel. They submit a certain number of names to the governor, and then from those 6 names or whatever it is that the law provides, the governor makes an appointment. And that system and many other of the merit systems have worked extremely well. Is it perfect? Do you have to ensure that the screeners or the people on the committee do have a broad enough representation vis-a-vis the community? Of course you do. And I think that the answer is, Alan, that neither system is perfect. The mixed system that we have in New York State does work well. I think ideally a merit system is better in the sense that if anything was perfect in terms of selecting, having a broad representation and selecting the absolute best people that also had a broad representation, that would be wonderful.
Judge, I have to change the topic a little.
Sure.
On criminal cases, how are judges selected? How do you select one judge on one case and another judge on another case?
Generally, most cases in the criminal side, as on the civil, are done off a wheel, either an automated wheel or actually a manual wheel.
And what about the high-profile cases? Do those?
There are cases where we have always said that while cases in general are done in what we call a random assignment way, we have always taken the position that where there's a case that requires particular skill, expertise, high profile, ability to control the courtroom, it may be that we reserve the right to say we're going to assign Judge X or Y to that case because we think that judge can handle that case. In 99% of the cases, that doesn't happen. Even in many of the high-profile cases, that doesn't happen. In a given situation, though, we do feel that there may be circumstances where you will want to make an appointment that's not strictly off a wheel.
The American people have been brought into the court system by Court TV. We all know about the O.J. Simpson trial. The people have been watching it during the day. You watch it at night. During the verdict, literally, the United States stopped for 10 minutes. Where all calls and everything, everybody was at the screen waiting for the verdict. What's your position on courts in our courts here in the New York?
Cameras in the court?
Yes.
In general, I believe that it is a very worthwhile educational tool. I think that you have to build in safeguards to make sure that it doesn't become a circus, that it doesn't impact on the actual proceedings. But if done right, I think it would be extremely helpful, extremely beneficial to the public. And our studies have shown that in general, having cameras in the court does not affect the judge, does not affect the jurors, does not affect the witnesses. It takes a little getting used to at the beginning, but you can do it in a relatively unobtrusive way that the camera is not an eyesore in the courtroom. It can work, and I think it shouldn't be judged. I mean, in my mind, cameras in the court shouldn't be judged on the occasional a mega case like the O.J. case, where everyone has an opinion about its impact on the system, look at Court TV and look at so many of the cases which have gavel-to-gavel coverage or wide coverage. It works. People understand the system better. And the example we always give is, it better to have, people say, well, you know, courts, cameras in the courts result in sound bites.
And circuses.
Well, not the circus. Sound bites where you take a particular part of the case and you see it on your nightly newscast. The argument, I think the counter-argument to that, is it better to at least see that small clip, or someone just talking about it and putting their own spin on the case? Even if it's a soundbite, you're seeing what happens. Can it become a circus if careful control isn't maintained? If the judge doesn't maintain the courtroom? If the circumstances around the courtroom in terms of security are not maintained? Of course it can be, with properly administered, with a judge who again recognizes it's there but doesn't let that camera change the trial. Again, it can be a wonderful educational tool, and most of our judges have handled it beautifully.
Let me ask you this. How do you handle it? Let's assume you have a judge who is not working as hard as you would like the judge to be working. Recently, the newspapers have had articles about one judge coming in not at 9:30 on the bench, but much later on the bench, and leaving earlier on the bench, or taking more vacations. How do you, and these might be duly elected public officials, how do you as the chief administrator handle something like that?
Judges are human like everybody else, and there are certainly, I would say, the vast majority of the judges, the overwhelming majority, are terrific, work extremely hard, day in, day out, way beyond the normal hours. Are there times where judges, like in any other business or government entity, where people have to be addressed or talked to in a way that's sensitive to the individual, yet recognizes that we could get more productivity? I'd be less than forthright if I didn't say to you, of course there are those circumstances, but I think an administrator who takes their job seriously, and judges who take their job seriously, treat this in a professional way, talk to each other, communicate, and with the goal, the mutually shared goal, and again, 99.9% of our judicial and non-judicial workforce are all going towards one goal, a fair and expeditious justice. And we do, where we have a problem, work with the judge or with the non-judicial personnel, and it works because, again, we're committed to a goal of serving the public.
But let's take the situation where you have, and I'm giving you just an example, and I'm sure there are situations like this, where you have a judge who really is underperforming, is not doing credit to the job and not putting in the hours or the services that should be put in. How do you handle something like that?
Directly and in a very forthright way. And again, I think if that's the way you treat it, and we don't talk about it, you know, in whispered tones, we talk to that judge, we bring the judge in. Judges want to perform in a way that brings them credit. They want to perform so they have respect among the peers and among the public.
But I have a 14-year term. I have a 14-year term, and I got 12 years left. What are you going to do to me?
What are we going to do to you?
Well, I'm a judge.
We're gonna.
I run my courtroom the way I want to run it.
We're going to treat you like a professional, and we're going to see to it that you're an assignment that makes sense, where you can be the most productive that you can be, and where we can serve the public in the best way by, again, ensuring that that judge understands, together with the administration, what we're trying to accomplish. And again, Alan, as in any other business, are there people who underperform? Of course there are. And then again, I'd be less than forthright if I didn't say that they are. But I'd also say that it is very rare that we have a circumstance with one of our judges that whatever the problem is, it can't be resolved, and again, in a way that serves the public.
And now I know another part of the administration of the chief judge, Judge Kaye, is bringing in more mediation into the courthouse and bringing more disputes outside the courthouse. How do you feel about that?
Right. We're very supportive of ADR and alternative dispute resolution.
What is that?
What it means is that as an adjunct, and the form of ADR that we favor is one that's an adjunct to the court process and doesn't replace the court process. The public has a right to come into the courts and have their disputes resolved by judges in the courthouse. By the same token, we certainly feel that there are certain kinds of disputes that may lend themselves to resolution in an adjunct way by a reference from the judge to either a very talented expert in a particular area, someone trained in mediation. We have had great success with it in various programs around the state. We're going to do more of it. The new commercial courts in Manhattan have an ADR component where we have 150 volunteers, trained mediators who are able to, again, serve as an adjunct to the court in resolving the tremendous volume of cases that we have coming into the courts and helping the courts, assisting the courts to move this caseload forward. We have in the state of New York 2.5 million cases every year. And certainly there are many different forums where those cases can be resolved. The courthouse is the first forum, but are there different kinds of ADR that can work? There can, and we intend to use it.
Judge, recently there was a decision by a federal court judge that said that the New York City Police Department overreaches in certain respects, and people can really be afraid of them in certain of our areas and literally run away from them.
Right.
How do you feel about that decision?
Substantively, as a chief administrative judge, I'm not going to take a position either way on the substance of the decision. But let me say to you that I think that there has to be a perspective by everybody, as again, whether the decision is right or wrong, that of what the role of the judiciary is. And that I do feel very strongly about, that the judiciary is a branch of government by Constitution, has the responsibility to interpret the law, to interpret the Constitution. If there are problems with the law, and this is particularly on the state side, if there are problems with the law, the policymakers are going to change the law, and that is their role. Our role.
What does that mean, Judge?
Our role is to interpret the law and to not necessarily to not be guided by each and every day what appears in the newspapers or the theory of the moment. The law is the law, and that's our goal.
On the other side, we recently had a book by a criminal court judge that said that he felt the system was too easy on the criminals, which he come before him every day, and that the Miranda warnings were literally putting criminals back on the street.
As an institution, we're not concerned with people who say the system is too hard or too soft. Our job is to interpret the law and to serve the public and perform our constitutional obligation as a check and balance on the other branches of government, and that's our role.
I could appreciate that. Yeah. But myself as a defendant, let's assume I came before this judge, and I just read this judge's book, and it says that he particularly feels that my rights, which are Miranda and all those things, really are improper rights, and that more criminals are on the street because of that.
Then the defendant or the defendant's lawyer should do whatever they think is appropriate in that circumstance. The only thing I can tell you is that we do our job each and every day in the courthouses of this state to interpret the law, and we don't take a poll in the courtroom or in the courthouse that day or on the street what we should do. The law is our job, interpreting that law, being the branch of government that doesn't make policy, but again interprets the law. That's
Judge
what we're all
Jonathan
about.
Littman, thank you very much for appearing on Lawline. I certainly wish we had more time.
It's my pleasure.
And as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.